Good afternoon, everyone. My name is Dan Baum, and I'm a director at First American Title Insurance Company. I'm here with Bryan, Leonard, my colleague and also my director. And I've been working at the company for about 3 years now. Bryan, same, right?
About 2.5.
Yeah, and so we're here today to talk about things that can sort of derail and delay a settlement. I know title can often be frustrating for you guys because you deal with, you have deadlines to meet and clients have expectations that they want to close on time. And so, we come in the same boat. We really do want to close deals. We don't want to make that problems for you guys. At the same time, we deal with issuing title insurance policy. And part of that is making sure that a property is insurable, and sometimes that requires dealing with complicated legal problems, and there's a lot of labor that sometimes goes into fixing those problems because no one wants to claim. It's bad for everyone. It's bad for us because we lose money. It's bad for your client because they have to deal with the claims process and having to deal with the stress of that. And it's bad for you guys as realtors because you don't want your clients have expectations that you're keep putting them in good hands. So you want to make sure that they're not going to have to deal with the stress of those claims. Just a little bit about myself. Like I said, I've been with the company for 3 years. I've been in title for 10 years. My first job out of law school was I was a foreclosure attorney. And then I branched into title, and I've been pretty much involved in every aspect of the title insurance industry, from policy prep to closing. I've done settlements, I've drafted HUDs, I've done closing. I had my own law practice and do closings from, the initial title search to closing the deal. So I've seen pretty much everything, and I've done a lot of closings in Philadelphia. So if there's questions, I'm happy to answer them. But we came up sort of with a list of the top 10 things that we sort of see on a regular basis, and just wanted to go through them and explain why they're a concern for us, and sort of give tips on how to anticipate these problems, in advance, so we're not dealing with it a week before closing and everyone's scrambling to try to close the deal. So, Bryan, you want to start us off?
Yeah, just a little background about myself. I graduated from law school about 2.5 years ago, took the bar, and then joined First American. Been underwriting with the PA agency group for a little over 1.5 years. So I've enjoyed it, and that's probably enough about me. So if you're watching the recording, we have a little handout sheet that we're going to refer to throughout the meeting. So maybe we can, if you want to watch it, we can email it. That way it can be, affiliated with this recording. So the first subject is old mortgages. Kind of an issue for us. We're worried if it's an unsatisfied mortgage of record that the lender could possibly foreclose at some point in the future, so we need to address this. We can't just kind of let it go. It presents a significant title risk for us. So I guess early on in the process, try to figure out whether the seller claims is telling us whether it's been paid but not satisfied of record, or if it's still open and we're going to need a payoff. Early on in the process, all of these topics, the earlier the better. Just full disclosure, try to figure out what the issue is, how we can resolve it as quickly as possible, to not hold anything up.
Yeah, just to add to that, when a title search comes out, it shows a list of all the mortgages on title. And it's going to depend on whether it's a current mortgage or a prior mortgage, because we sort of have different ways of addressing it. If it's the seller's mortgage that they paid off a long time ago, but it's never been satisfied, we're probably going to want to have more seller involvement in getting it satisfied, because it's really his debt, and he should have documentation showing that he paid off the loan. So that's sort of the items we want to look for. Title companies often, they deal with these issues a lot, so they have ways of researching who the lender is and contacting police departments. A lot of times the problem is that we can't, it's an old mortgage from like a mom and pop's lender. and we don't know who to contact to get a satisfaction. But title companies often have we have vendors or we have ways of researching this and figuring out. A lot of times it turns out that Wells Fargo is a success or TD Bank or Bank of America, and then if we know that information, we can contact them and get them dissatisfied. Yeah.
Do you have any do you need more time for mortgages like that are special, like reverse mortgages, for example? Say that somebody, an older person has owned the house for a long time, maybe took a reverse mortgage or one of those all age mortgages that.
I would say with reverse mortgages, it would come down to, it's gonna be a problem if the person's dead, right? Because if it's an estate sale, for a lot of reverse mortgages on title.
No, person is alive.
The person's live.
Because then is another issue.
And it would depend on the lender. I mean, if it's a reverse mortgage and the person's alive, they should be able to, is it like in your fact pattern, is the person able to?
Yeah, I had a
situation
situation where the person will swear that he paid out the reverse mortgage or their family members, I don't know. And it turned out, later in the deal that it wasn't. I was on the buy side, so it was, yeah.
So you're saying the loan wasn't paid off?
The loan wasn't paid off.
Yeah, I mean, so that's the concern we have as because we're insuring your buyer that there's no debt on the property.
Right.
And if it turns out, even though it's an old mortgage and the seller says, I paid it off,
Sure.
it turns out that the debt is live, the lender theoretically could foreclose.
And all of that will show at the time where you do the title search.
So how it basically, when you get a title insurance commitment, it's basically telling you, we've searched the title and we're showing you everything that shows a record that hasn't been satisfied. So an unsatisfied mortgage will show up because it's indexed in the recorder of deeds office to the property.
Okay.
So if it's unsatisfied, the question we ask is why. So has it been paid? In terms of getting the mortgage holder, the mortgage, like the lender that owns the debt to issue a payoff, it sort of depends on how cooperative the lender is. I mean, if the borrower's alive and can provide payoff requests, I mean, with their signature, I mean, I don't see why they would refuse to provide it. It gets a little more complicated under reverse mortgages when the borrower's dead.
Yeah.
Because you need borrower authorization to get a payoff, and how can you do it? Person is dead. Usually, you need proof that there's a executor or administrator of the estate to send over letters testamentary showing that whoever's the personal representative has the authority to get a payoff.
Sure.
So it's really as soon as the commitment coming out, researching who owns the debt and getting a payoff. In the prior owner context, like if your buyer bought a property from someone else and it's their mortgage that hasn't been paid off, then there's usually better ways of resolving it because likely your buyer, the seller to that transaction should have gotten title insurance, and we can redress that.
Or me as an agent, I will be requesting the payoff documentation or whatever.
Yeah. So, anything else about mortgages?
No, just, if it's a mom and pop shop, the example you used where there's a successor entity, then again, it might take a little longer to figure it out.
A lot of bands that, no longer in existence,
It all depends on the creditor. We have no control over their lien release department. But what I'm saying is the quicker we deal with it makes it less likely we're going to be scrambling to try and close the time and having to deal with an escrow. So yeah, so I mean that's the main thing with mortgages. It's just figuring out who owns the debt and addressing it as soon as possible.
Mm-hmm. Yeah, I think that covers that. So if you don't have another question about mortgages, move on to estates and inheritance tax. We see it pretty often where a state is selling the property and for our purposes, the issue is when the property owner dies, inheritance tax lien automatically attaches to the property. So in order to convey real property, we need the court to appoint a representative of the estate. If there's a will and it's going to be probated, the estate that is, there's going to be an executor. If it's going through a testacy, then it's going to be an administrator. But either way, that's the personal rep of the estate who will ultimately need to convey the property. In terms of inheritance taxes, it's best if the estate hires an estate attorney to kind of accelerate the process of filing a return, listing our property in the proper schedule if it's owned by the decedent, Schedule A of the inheritance tax return. Once it's reported, we hold an escrow. The inheritance tax rate is based upon the relationship between the decedent and the heirs or beneficiaries. So if it's children inheriting the property, it's 4.5%. If it's sibling, it's 12%. If it's non-linear, so like grandparents, parents, children, grandchildren, that's 4.5%, not just children. And if it's not a linear descendant or a sibling, it's going to be 15%. So
yeah, and just to sort of reiterate and maybe simplify a little bit. I mean, when we're dealing with the state, we're dealing with two real things. We're dealing with an authority issue because who can sign off on a dead guy's house? So there's got to be a legal process for appointing a person to act on behalf of that person that died.
This is a general question. So how long for a state that doesn't have a designated person or executor, right? How long the probate process taking nowadays in Philly?
I don't know. I mean, I don't. I'm not an estate attorney, so I don't do the probate process. I know, like, a lot of probates in Philly are done per se, which is probably not a great idea, but they do get done. But I don't think it takes too long to get letters issued because I don't think there's a full court process. I think the register of wills just needs proof that the person has, either authority under the will to be the executor or they have some relationship to the decedent if it's in the estate. So when someone dies, just generally speaking, they either die testate or they die intestate. If they die testate, that means they died with a will. If they died intestate, that means they died without a will. And so state law governs who inherits the property.
Right.
But in both situations, a personal representative is appointed. In the will context, intestate, in testate, an executor is appointed. In intestate, where there is no will, an administrator is appointed of the estate. It's different names, but they do the same thing. They have the authority to act on behalf of the estate. So first issue that needs to be resolved when a estate is the seller.
Chef for many years and jazz musician. Yeah, so daily. Yeah, I'm happy to share.
themselves.
And sorry. And so the one issue is dealing with authority. There's got to be someone who has legal authority to execute, handle the affairs of the decedent and sign a deed, sign the settlement sheet, stuff like that. And then the other issue is, of course, inheritance tax, because like Bryan said, when someone dies in Pennsylvania, all the assets that they own are subject to inheritance taxes. And it's automatic, meaning that it's an invisible lien. It's a silent lien that attaches to all property that the decedent owns, including real estate.
Mm-hmm.
And so if that's not dealt with at our settlement, the buyer is taking that property with the lien attached to it. So they're taking a property with inheritance tax debt of the selling estate. So that's why we have to deal with it at closing. And a lot of the times it's, it hasn't been paid yet because it's just, they're trying to sell property to basically pay the tax because they, maybe the estate doesn't have a lot of liquidity.
Mm-hmm.
And so they need to sell the real estate to pay the tax. So, and we understand that, but it's still a problem for us, and we got to make sure that if the tax is gonna be paid after closing, that our buyer's protected. So a lot of times we deal with it, you've probably seen an inheritance tax escrow.
Yeah,
Yeah, that's just because a lot of times the estate's selling the property before the administration of the estate's complete.
Yeah.
You know, it's kids who want to sell mom and dad's home before everything else is finished, so we gotta hold an escrow,
Yeah.
so cover that.
and usually the time of escrow, do you have like a specific time? Where do you keep that in escrow, like?
We would,
A year, 6 months or whatever.
I mean, essentially, at least our policy is that we hold it until the liability is gone. So the taxes, our property needs to be reported on an inheritance tax return. They have to pay the tax, and the Department of Revenue has to issue a letter that says, we agree with what the estate said the tax was due, and you've paid the tax, and we agree that nothing further is due. That's good evidence for us that there's no inheritance tax issue and we can release the escrow. If the inheritance tax escrow is sort of forgotten about, meaning like we've closed, held an escrow, and the seller doesn't care about the money, he's just, we don't hear from him, then we'll probably have to call the Department of Revenue and get them to provide us a payoff for giving a lien release to the property, and then we'll release the area.
Cool.
Okay, we'll move on to divorce, which can be a tricky one. Pennsylvania is an equitable distribution state. So marital property is equitably distributed in a divorce. Marital property is generally property acquired during the marriage, but with respect to real property, it can also apply to an appreciation value of the real estate during the marriage. So say wife buys property, well, I shouldn't say wife, but individual buys property while he or she's single, then gets married and then divorced. The appreciation in value from the point they're married until they're divorced is considered marital property. From our perspective, we're concerned about that because either spouse may have an interest, so we ideally like both spouses to sign off. That's assuming that the divorce is ongoing and there hasn't been a final decree entered and a property settlement agreement executed. That's assuming the divorce is still ongoing. We'd like both spouses to sign off.
Yeah, and I think Bryan pretty much summed it up. I mean, it's just it's really fact specific, and it sort of depends on you have no control over the facts and circumstances of a property that's being sold during a pending divorce, and it sort of requires the cooperation of parties. So I mean, that's something. All I can say is, you need to set expectations. If you're gonna, list a property for sale and you find out that there's a pending divorce, it's better to address it with the title company sooner than later, because if they find out about it through the title search because there's a lawsuit on the title, or it gets disclosed before closing, it's going to be a lot more difficult to deal with. So, and like Bryan said, the reason that we need both spouses to sign off is because there's potential equity that could be disputed. We want to make sure that there's not going to be a claim by a disgruntled spouse that didn't get part of the sale proceeds. So, all right. The next subject is power of attorneys. Have you guys dealt with power of attorneys before? Okay, so just brief summary of what it is. It's a document that gives authority from a person to handle the affairs of someone else on their behalf. So the way I think of it is there's two people involved in the power of attorney. There's the principal, the person that's giving the power of attorney. They sign the document saying, I'm granting authority to this person to handle my affairs or to sell real estate on my behalf. And then there's the agent, that's the person vested with the authority to act on behalf. And they have legal powers to act on behalf of the principal, but they do have a fiduciary obligation. They have to act in the principal's best interest. So why it's a concern for us is generally a power of attorney. I know sometimes there's a lot of pushback from title companies about power of attorneys. And the reason is, the concern for us is, we want to make sure that the person that owns the property knows what's going on, that they're aware that the property is being sold, and if they're not aware, we want to know why the power of attorney is being used. So, we come from a legitimate perspective of making sure that, someone's not going to get swindled, or someone's, not going to be like, hey, why did my house get sold? So that's sort of the initial concern.
The principal's giving a lot of power to the agent, so we want to make sure there's no fraud or something up with the sale. We want to figure out
and we want
why they're using it.
Yeah, and maybe not even fraud, but just making sure that this type of sale was contemplated when they provided a power of attorney for that person to act on their behalf. So that's sort of the hesitation we see when those are presented to us, because we don't want to have a situation after closing where the actual owner of the property is like, why did this person sell my house? Because that becomes a problem for our buyer.
I'm sorry, can you spend a little bit on item B? On your, what are the requirements, or what am I looking, as an agent, right, I'm presenting a power of attorney.
Yeah.
My first instinct is to send it to the title company, hey, is this good?
Yeah, so I would say always send the power of attorney to the title company for approval, and we'll do the job for you. But for the most part, in terms of the statutory requirements today, meaning power of attorneys, I think executed in 2015 on
January 2015.
So for power of attorneys executed 2015 onwards, they basically have a witness requirement and a notary requirement and a notice requirement. So I'll go through them. So basically, every power of attorney executed in Pennsylvania has to have 2 witnesses, and they have to have a notary. And the notary can't be the witnesses. So the witnesses have to. You basically have to have 3 independent witnesses that have acknowledged this person signing the document. So that's the first thing. The other thing is there has to be a notice to the principal and a notice to the agent. The notice to the principal is essentially like a Miranda warning. It's basically saying, hey, this is what rights you're giving to someone else to act on your behalf. They have to act in your best interest, but this is potentially what they can do. So they have to basically sign the person giving the power has to sign a disclaimer saying, I understand that I'm giving someone the authority to act on my behalf, which may include things like conveying away my real estate. The power. So there's witness requirements, there's notarization requirements, there's statutory disclaimer requirements, and then the power of attorney itself has to give the authority, which is being used in the transaction. So that it's got to give the power to engage in real estate transactions. So when we look at a power of attorney, when it's provided to us, we're going to make sure that it meets the statutory requirements, but we also want to make sure that the power of attorney says that, if the agent is selling real estate, we need to see that the power of attorney gives them authority to sell real estate. I've done a couple closings where sellers try to use a power of attorney the power of attorney was executed specifically for them to purchase the property, and now they're asking for it to be used to sell the property, but the power of attorney only gave them the authority to purchase the property. So we couldn't use it because the agent would be exceeding the scope of their authority, because that power of attorney said all it said is you can buy the property, it didn't say you can sell the property. So those are the things we look at with review of the power of attorney. But I mean, to avoid hiccups, the day before closing, send it to advance. And a lot of it has to do with the comfort level of the title company. The title company is going to want to know why it's being used. Like I said, the concern is we want to make sure that the true owner, like this is a legitimate sale. And if it's sprung up to us at the closing table without acknowledged, we're going to be a lot more concerned, because it's at the closing table. The settlement agent has to make a snap decision about whether they're going to approve it or not. They may have to call an underwriter. The underwriter might not be able to get them on the phone. So it's a lot easier to deal with if the circumstances of why the power of attorney is brought to the attention of us in advance.
Yeah, the statute lays out the notice provision that Dan mentioned, that, okay, I'm signing away all these rights. that's verbatim what's required under the statute. It's a specific document. And then the agent acknowledgement too, where the agent's signing and saying, I acknowledge that I have this fiduciary responsibility to the principal.
I think if you see enough of them, you get used to seeing what they look like. But I mean, for the most part, you know, we're looking for 2 witnesses, notary, and those disclaimers, and that the power of attorney engages in real estate. And like I said, it's going to vary with title company based on their, you know, the level of comfort, how it, you know, how it's being produced, what the reason for. You know, I would say if a power of attorney like is being contemplated to be prepared, I would recommend that it be done at a law office, because I would be a lot more comfortable seeing a power of attorney presented to me that's prepared, you know, at a law office than with no name on it, and it's executed at a UPS store in somewhere in Philadelphia, because you know, I don't know what the circumstances are by the POs.
Yeah, there's instances as well where like some sellers will want to give you, especially when they're moving away or like in a relocation situation, they'll want to give you power of attorney close into their settlement documents. I feel extremely uncomfortable about that.
Yeah, I think the best situation for that, I think I'm going to address a little bit about out of country sellers, because we're seeing a lot of that more often where people are out of the country. We have to figure out how to get a deed to the closing table from you know, Australia or wherever they are. But yeah, I mean, the way I usually address it is get a deed package out to them and then have them sign a settlement authorization form for you to sign the HUD. I mean, when I was doing closings, I basically would send a deed package, and if there was no way for them to physically make settlement, I would send them over a copy of the HUD so that they had a chance to look at it, and they send a settlement authorization form saying that the realtor can sign on behalf, or whoever's going to sign it on behalf of the seller. But I mean, if the seller actually signs the deed, you know, there's a lot more comfort from our perspective that they're aware of what's going on because they signed the deed. So out of country sellers, like I said, I've been seeing that a lot more, and you know, it's not really a title issue, but it sort of is, because it presents a huge logistical issue for getting a deal to closing, because you know, we have to have a physical deed in our possessions before we're going to be able to record a document. So there's sort of ways to deal with it, but the best thing to do is, you know, if we know the seller is going to be out of the country or just unable to attend settlement, getting a deed package out as soon as possible is sort of the best way to deal with it. In terms of there's sort of a couple ways to deal with an out of country seller. I mean, the best way we want to deal with it is to, you know, tell them to get an appointment with the embassy, the United States Embassy, as sooner as possible, so that they have an appointment ready to go. So when that deed package gets to them, they can get it notarized and the document signed. If that's impossible, or it's not, you're not going to meet the sale contract deadline, you may have to look at getting an apostille service, which basically is it's done by the country has to be a member of the Hague Convention, and it's a little complicated, but you can always talk to the title company and they'll work it out with you. But basically, apostille is an alternative to U.S. Embassy, where a foreign country notary can sign as long as there's an apostille attached to it, which basically verifies, pursuant to international treaty, that it's a legitimate notarization. The only thing is the document has to be completely in English, because if it's in a foreign country, a lot of times the notarization gets done in a foreign language, and so we require a certified translation into English so that it can be recorded. And then the other option is remote online notarization, which is becoming more prevalent. But you gotta, if that's sort of an option, I would suggest talking to a title company about what the requirements are. They're very strict as to the signing requirements for Iran. There's a lot of knowledge-based authentication that goes into it, into proving the person that's signing remotely is who they say they are. Yeah, if I would just say, like, in terms of out-of-country sellers, if you're aware of it, let your settlement agent know as soon as possible and talk to them about scheduling an appointment with the embassy. I think that's pretty much it, because it's just a logistical issue. In terms of Philadelphia issues, I dealt with this a lot, broken water meters. So I had a law practice and I used to do closings in Philadelphia, and I was doing them during COVID, and the Philadelphia water meter shop was closed down, and I was doing a closing for a property that sold, and they had a broken water meter, and we couldn't get the water meter repaired because of COVID. So we had the only option which to my reluctance I didn't want to do, but to get the deal to closing, I held a water escrow, and after closing, it took like 3 years for the seller to get his money back because we couldn't get the cooperation of the buyer to let the Philadelphia Water Company onto the property to service the water. So it's a real problem. So just backing up a little bit, in Philadelphia and a lot of different counties, water and gas are municipal debt against the property. They run with the land. So when your buyer buys a Philadelphia property, they're buying the property with any in-rem municipal water and gas on the property. So if the seller has back usage, like they've had water usage that hasn't been built yet because the water meter hasn't been checked, the water meter will eventually get checked, and then that will get billed to the new buyer. And the buyer doesn't want to deal with that, right? They don't want to pay for the seller's water usage.
Right.
The problem arises when you have a broken water meter, because the title company relies on the water meter to determine how much water the seller's used, so that they can either advance pay or they can credit the buyer for the seller's water usage. So yeah, it's a real problem because I'm not a big fan of escrow as a solution, because there's really no way to determine the amount of water hold. I mean,
Yeah,
who knows
it can run.
Yeah, I mean, if there's especially if it's an investor property and they bought it through foreclosure and there's discontinued accounts, there could be $10,000 of water.
Oh yeah.
So there's really no way to determine how much to hold. And like I said, my situation, when we closed, we couldn't get the buyer to cooperate. So the seller maybe, if you're holding $20,000 because you have no idea how much water is due, and the seller can't get that back because the buyer won't let the Philadelphia Water Company on the property, it's going to be a nightmare.
So quick question about that, because I was exactly going to bring that up, especially in properties that are being rehabbed, right? Where they remove the meter or whatever is broken. So when there's no way for the water company, I mean, let's just say that it's been leaking for a long time, a huge bill comes out, like, is there any way to, or in your experience, is there any negotiation or any room that the city allows, especially if there's no meter, because there's not an exactly.
Well, they should be able to install a new meter, right?
Yes.
I mean, I think the best way to deal with it is to, like, if you're listing a new property, is to inquire with your seller. The day of, I would be like, do you know if the water meter is broken? And if they say, I don't know, tell them to call the water department and ask when the last actual reading was done, and if they think the water meter is broken. Because the sooner that can be fixed, it won't have to be, you don't even have to resolve it with the escrow. Because the title company is going to be like, I don't know what the water debt is against this property. It's not my, my burden to basically have to insure unknown water debt against the property, especially in an investment. It's not fair to the settlement agent. So that should really be resolved sooner than later. I mean, there's multiple ways to deal with it. I mean, like what I propose is probably the best solution. If it's going to be by escrow, you may see egregious escrow sizes, or you may see buyers that are willing to take an exception for the water and deal with that outside of closing. So I think the best solution is to deal with it sooner than later, and if it turns out that it is broken water meter, we get it fixed as soon as possible.
Okay.
Touched a little bit about construction. So, construction is sort of a risk for us as well because, second. So in Pennsylvania and other states, there are legal protections for contractors for work performed. So the idea is that if you're a contractor and you worked on someone's house and you don't get paid for it, you have sort of a financial interest in their house because, or their property, because you've increased the value of their real estate with your work, with your labor and your materials. So the law in Pennsylvania and a lot of other states protect contractors for work they perform and haven't been paid for by allowing them to file a mechanics lien, which is basically a lien. It's evidence of debt on title. So they file a mechanics lien against the property, and essentially, if the owner of the property wants to sell it or refinance the property, they're going to have to address it at closing, which generally means that the contractor is going to have to get paid. So the other thing that's unusual about construction is that the lien starts from the date of visible commencement of work. So it's not when the lien is docketed. The second work starts, which means it could be excavation, demolition, shovel in the ground, dropping supplies on the ground. Potentially, if that contractor doesn't get paid and he files a lien on that property, that lien will have priority from the date work started. So it will affect an interest in real estate that occurs after the commencement of work. So it becomes a real problem for title companies and for buyers, because we want to make sure that when you're buying a property, there's not going to be unfiled mechanics liens that will attach to the title. So just quick tips for prior constructions. If you're representing seller, ask them about it, keep up to date, make sure that they keep up to date on their payments, and that they have proof that any work that they paid for, they have paid in full receipts. And in the event you get a title back and it shows a mechanics lien on the title, I would suggest that they talk to a construction attorney or someone that deals with construction lawsuits, because there are ways to basically get the lien removed from title without having it paid. Like there's procedural ways to deal with it, such as entering bond into court and paying the debt in dispute into the court system, and then the parties can fight it out then, but the property can get sold. So we can address them, if they show up on your title report, talk to your title company and figure out ways to resolve it. And then new construction, my experience is that it's much easier to get a construction loan if work hasn't started yet. It's just to get a construction loan, you have the lenders want mechanics coverage. They want to be insured against mechanics lien, and it becomes harder to get mechanics lien coverage if work's already started, because, like I said, the visible commencement of work. If we're recording a mortgage and work's already started, and a contractor files a lien after the mortgage gets recorded, that lien potentially relates back to the day work started. It's potentially a greater interest in that mortgage, which is a problem for the lender and a problem for us. So yeah, I would say if you have a prospective buyer that's going to construct new property and they want to get a construction loan, to talk to a loan officer and talk to the title company about what their requirements would be before you contemplate starting work, just to make it easier to get that loan. So that's all for construction. And then quickly about judgments. So it's pretty simple. If you get sued and you lose, they'll file a judgment against you. That judgment becomes a lien on all your property in the county where the judgment's filed. So that's another lien on title, similar to a mechanics lien, or similar to a mortgage. It has to be paid off at closing. Best way to deal with it is to get the title report back, look at the judgment list, and go over it with your client, and determine, are these judgments yourself, because sometimes it's same names, similar names, but it's not them. So yeah, my recommendation is to look at it as soon as possible and determine if these are actually judgments that your seller owns, and if they're not, just be prepared to give an explanation why they're not. Like, a lot of times you can deduce that it's not the same person because they have a different date of birth, different different address. So there's ways to give evidence to the title company that it's not the same judgment. If it is a judgment against your seller, then you're going to want to get a payoff sooner than later because, in my experience, they've been harder to get from judgment creditors than are from mortgage payoff companies because they deal less with the sales of property. So, yeah, my suggestion is if a judgment is against your seller, to take a look at the lawsuit, see who the attorney is, and call the office and get a payout so that it can be paid at closing. Pretty much it for judgments.
Okay. I think the last subject we have is LLCs and business entities. So I think partnership, corporation, LLC, some entity that's not a human being owning the property. Kind of like powers of attorney and with the states who's going to sell the property, it's an authority issue for us. So, yeah, the LLC owns the property, but who on behalf of the LLC can actually convey property? So we're going to look for the formation documents for the entity and then the governance documents. So LLC, we want to see certificate of formation and an operating agreement. The corporation, we want to see articles of incorporation, was it incorporated, where it's done properly, and then bylaws, partnership agreement for a partnership. We basically just want to review the document, see which natural person or persons have or has the authority to sell real property and act on behalf of the entity.
It's funny, like I've heard this from investors a lot, that they say that they want to put their name in like a Delaware LLC, but they want to put their property in a Delaware LLC because it hides their identity. And I understand when they do that, but the caveat, like the double-edged sword to that, is that it becomes harder to prove that you are the owner of this LLC if there's no public record of your name associated with this company. So just bear in mind that you want to have good records. Like if you're going to put your name in a business entity and there's no public record indicating that you're the owner, make sure you have good documentation showing when you created the entity and even when you purchase the property, like your settlement sheet from when you purchased it, your marked up title. Because if you can produce that, that makes the title company a lot more comfortable that you need extra owner like that. That's pretty much it. We listed unusual title matters. If you guys have any specific questions,